Rich Goldstein here at Resonate 2021, and I'm really thrilled to be here to talk with you about how to protect your products and brands. In general, when we're talking about protecting yourself, protecting your products, protecting your branding, protecting your content, we're talking about the area of the law known as IP. And IP is also known as intellectual property, or it's an abbreviation for intellectual property. Intellectual property meaning property of the mind, and it breaks down into a few main areas. The main areas of IP are patents, trademarks, and copyrights. And we use patent, trademarks, and copyrights to protect products and apps, also branding, and also our valuable content. Now, why is it important to protect your brands and your products? So I've been in this field for over 27 years at this point, and it has evolved over time. In general, the main reason people often look to protecting their products, to protecting their brands, was to prevent competition, to prevent others from coming and taking the things that you have put your time and energy into creating, whether that's a new product idea or whether that's branding that's become so powerful that other customers are looking for that branding. And you want to protect your bottom line. You want to prevent people from taking revenue from your top line, even by jumping on the bandwagon of whatever it is you're doing. So that's been the most traditional reason why people have protected their products and brands. But as of recent, it's evolved significantly in another respect. And that is that when you own the rights to your products and your brands, it can multiply the value of your business at the time of acquisition. And more and more businesses, especially e-commerce businesses, are being acquired these days for higher and higher amounts of money. And having an IP portfolio can make a huge difference in what you get paid when you go to sell your business at the time of exit. And just a little illustration of this: it's kind of like if you don't have intellectual property, then the value of your company is going to be based upon what you've been able to create by way of market share. So there may be a certain amount of sales that you've generated, a certain customer base, and that results in certain profit or EBITDA, and then you're going to get some type of multiple based strictly on what you've been able to create with your company. To an extent now, though, the multiple you get on that EBITDA is increasing as other opportunities might be available. So it's like when a company that's acquiring you sees that there's a possibility of expanding into a different channel, that could increase the multiple that you get. But if you don't have any IP, it's really based on kind of what you've created, like what your current business is generating, and then their ability to just continue on that road a bit longer. So you get a multiple. They expect that they might be able to continue down that road of earnings for another few years, and then you get a multiple of a few times. That's when you don't have IP. But when you do have IP, then something else is available. All of those other possibilities of expanding into another channel, of expanding the brand into other products, like that's the opportunity that goes well beyond the market share that you've been able to create. It goes well beyond that little piece of the pie that you've been able to create to date. And that's part of what they're looking at when they're looking at buying your company. They're saying, hey, we can take what they've created and we can do that much more. And if you have the exclusive rights to a certain type of product and other companies can't jump in and just do the same thing, then they're looking at the opportunity to get the whole rest of the pie that you haven't been able to get to date. So with intellectual property, it could dramatically increase the value that you get at exit. And so that's a significant reason to look at now. Like I said, traditionally, people would look at the value of IP during the operation of the company, the way in which it can help prevent revenue loss, the way it can affect the bottom line of the business as it operates. But these days, having an IP portfolio, having a good IP portfolio, can really multiply the value that you get at exit. And it could be a huge ROI on the money that you spend on IP in general. And also, we're talking about platforms, a platform like Amazon. If you're selling on Amazon, uh, I mean, everybody knows. I'm sure everyone listening knows of someone who has been shut down due to an IP complaint. It may be you, maybe someone you know, but it's very, very common. And having your business shut down because of an IP complaint can have a terrible effect, especially if the end result is that you have to destroy inventory and maybe lose a listing that's been very profitable to you. So um, it seems that Amazon has been deferring to IP owners to a large extent, especially with design patents. They think it seems reasonable that someone's infringing. They will shut down that infringer. And so if Amazon is deferring to that IP owner, then it pays to be the one holding the IP. Okay, so in general, now you want to protect your products and brands. It is a three-step process. This is one way to break it down. So whether we're talking about patents or we're talking about trademarks, it's the same basic type of inquiry. And I'll show you how, and I'll show you how it expands out to look at the specific things you need to look at for each of those. Like what things you need to consider if you're going to patent something, what things you need to consider if you're going to trademark something. So first of all, here's the overall three-step process. Step one is you determine if it qualifies. So, does it qualify for protection of the type you're seeking? Step two, is it different enough? And when it comes to anything, protecting any type of idea, I think it's fundamental that it has to be different from other things to be protected. But that standard is an important one to look at when we're talking about patents or when we're talking about trademarks. Again, we'll get to that. And then the third step is you file for protection. So once you determine that it qualifies and that you determine that it's different enough, then you could file for protection. So step one, does it qualify? Now, to qualify it, it has to be the right subject matter. In other words, the right type of thing. And it also has to be the right timing, because sometimes the timing is wrong and it's either too early or too late. So in general, if you're talking about products or product ideas, then you're talking about patents. So whatever differentiates the product itself, that's the territory typically of a patent. If we're talking about branding, then it's a trademark. So the name, the logo, the things that brand it and set it apart from other products in the field so that people think of your company when they think of that branding, that's what a trademark is for. And then when it comes to content which could be literary content like the words in a book or the words on your web page or images or music, that type of content can be protected by copyright. So again, P for products, P for patents, easy to remember, C for content, C for copyrights. Branding, trademarks doesn't quite fit there, but just remember that. If it's a product idea, then it's a patent you're looking for. If it's branding, it's trademarks, and content, copyright. Okay, and I'm going to focus on the two main ones that sellers of all kinds, e-commerce sellers, really need to look at, and that is patents and trademarks, because that's how you protect your products and that's how you protect your brands. Again, the products with the patents, the branding with the trademarks. So now, looking more closely then, it's got to be the correct subject matter. So for a patent, it's got to be a product, and that could be a physical product. It could be a chemical composition. So if it's a type of supplement, for example, different combination of ingredients, it may be possible to patent it. Or if it's a skin lotion that has a different combination of ingredients, that could be patented as a chemical composition. If it's a process, nothing specifically different about the product itself, but it's a different series of steps, maybe a manufacturing process, that could be patented. And then lastly, when we're talking about software or an app, that could be protected by a patent as well. And it's actually the process of the software that gets protected. But in general, those things can be protected by a patent. And as we'll talk about in a few moments too, might refer to a physical product. That can mean the structure of it. It could also mean the design of it. And again, we'll talk about the distinction there momentarily. When it comes to trademarks, then the thing that's protectable, again, is branding. And so what do I mean by branding? I mean the things that when people see that, when people see these items, they think of your company and your company alone. So the name of the product, the name of your company. It could be a phrase like Nike's "Just Do It," that they think that refers to one particular company in a certain type of in a certain industry. Same thing with the logo and a slogan, kind of similar to phrase like "Just Do It." Those things that distinguish your product or service in the marketplace. So for Coca-Cola, it could be the name Coca-Cola. It could be that script writing style for Coca-Cola, that logo. It could also be, the real thing slogan for Coca-Cola. It could also be that red and white color scheme on the can. Those things that when people see them, they think of Coca-Cola in particular. And if those things were used by a competitor, it might confuse customers into thinking that they were buying a product that really was a Coca-Cola product. And if it's not, that creates what's called a likelihood of confusion. And likelihood of confusion is a trademark issue. So in general, what you want to do is you want to protect those things that a competitor might copy and confuse your customers into thinking that they are you. You want to prevent your customers from mistakenly buying one of your competitors' products thinking they're buying a product from you. That's what trademarks are all about. So again, having the correct subject matter is what's key here. The product, the composition, process, software, that's the domain of a patent. And then the word, phrase, logo, slogan, things like that, that gives you the right subject matter for a trademark. So that's part of step one, is it's got to be the right subject matter. And now, expanding further on the patent side, there are two types of patents. So there is a utility patent, and this is what we typically think of when we think of a patent. We think of someone inventing something in their garage, someone trying to improve upon an existing product, make it that much better. So to do so, they're making some type of structural improvement or functional improvement. And so in general, a utility patent is for the functional or structural differences from other existing products. So when we're thinking of an invention, typically, we're thinking of a utility patent. And then there's also a design patent, which has to do with the physical appearance of a product only. It's only about what they call the ornamental appearance. So it's like you got a water bottle that just functions like every other water bottle, but it has these grooves, these ridges, these curves that go all around it. That could be a design patent for the shape of the product. It's the non-functional shape of the product is what gets protected with the design patent, just the ornamental appearance. Now, design patents have become extremely important on Amazon. And one of the reasons is that utility patents define an invention conceptually, and they define them in words. And it's often difficult to interpret the wording of a patent, whereas a design patent is just about the physical or the ornamental appearance of the product, and it's just a matter of how it looks. Does it look substantially similar to the product that's in the design patent drawings? So if you did an IP complaint on Amazon with a utility patent, they're going to say, we don't know how to interpret this. You have to go through our neutral evaluation procedure. But with a design patent, if it looks similar, chances are they're going to shut down the competitor's listing. So in general, then a design patent has become extremely valuable on Amazon because it becomes an easy path to stop competitors when they copy a product just like it is. I mean, most of the time, people don't get imaginative when they copy a product. They just copy the same product, and then it's going to look the same. And if you have a design patent, you'll be able to shut them down easily. So again, one of the reasons why it pays to be an IP holder is that Amazon seems to be deferring to IP holders. But that distinguishes the two types of patents. Again, we're still on step one here of determining that it's got the right subject matter. And the next part of that is it's got to be done at the right time. So um, the the right time is extremely critical for patents, and most people don't realize that. Is that if you ever want to apply for a patent, it has to be done before it's public, or you lose the rights in much of the world. And in the U.S., there's technically still a 1 year grace period. So if you haven't applied for the patent and a year goes by from the time at which you've made it public, you've listed it, or made it public in some other way, then it's game over. It's too late to ever apply for a patent. So one of the reasons why you want to figure out at an early stage, is this something that I ought to be patenting? As I'll mention later, not everything should be patented, or you shouldn't try to patent everything. But if it is something that you ought to be patenting, you need to look at that at an early stage. And then trademarks, it's a little bit different when it comes to timing. With trademarks, you actually need to be using the mark to get the to complete the process of trademarking. So you need to be using the mark. You can apply before you start using it. That's called an intent to use trademark application, when you apply before you've actually started, and that could be an important step to take. But you do gain rights by using it out there in public. And then if you did apply for it early, as I'll explain later, you will need to show that you are using it to finish the process. So the timing issue is different here with regards to patents and trademarks. Patents, it's got to be done early or you lose out. Trademarks, it can be done just before you start using it or after you've already been using it. And in general, there's no time, kind of like time deadline where, if you haven't applied for the trademark, then you've lost it, except for the fact that other people can step in ahead of you. Other people filing the application ahead of you can cause a big problem. So it's just a different situation between patents and trademarks. But it's important to know. Don't delay too long filing your patent application, because it might be game over. With trademarks, it is more forgiving, is a way to look at it. But filing early has tremendous benefits in not getting beat out by someone else who gets the trademark office before you. Okay, now the second step, is it different enough? So now that we've determined that it qualifies in step one, step two, is it different enough? We want to know on the patent side of things, is it's got to both be new and non-obvious. So new is expected. Like, new is kind of like what we would think is like, well, it can't be this exact same thing as things that exist before. But non-obvious requires that it be something even more than that. Even if the exact same thing hasn't been done before, it has to be outside the range of what people would think to do. Same thing would be the case if you said, I want to make clothes hangers that are a specific size for small children. And, imagining that didn't exist and all that existed was the standard size coat hanger, the patent office would still say, hey, that's obvious. It's obvious to simply change the size of this. Granted, they're out there in a standard size, and that's because it's for efficiency of manufacturing. But people that make these things know that they can make them any size. Therefore, that would be obvious. So, in general, for something to be patentable, it has to fall outside of the range of what's expected. Even if no one can find an exact example of the exact thing that you're proposing patenting existing, if they find part of it in one patent and part of it in another patent, and they're really closely related, then the patent office would make the conclusion, hey, it would probably be obvious for someone in the field to put these together. So, must be new, must be non-obvious. When it comes to trademarks, different standard. It has to be distinctive. It has to be distinctive in a way that it doesn't kind of directly describe the product. Like, you can't trademark red licorice because red is a characteristic of the licorice, and so you can't trademark a term like that. It would prevent people in the industry from directly describing their product, just like you can't trademark fast computer because it's just a characteristic of the computer. So it has to be something distinctive. And kind of the more unusual you get with the naming of the product, the more distinctive it is. So on one level, if it's something which just kind of suggests a characteristic of the product, then it could be considered distinctive. Something like, like northern forest air freshener. It's not directly describing, but it's suggesting something about freshness, etc. But then moving further up the scale, if something is arbitrary, like Apple for computers, that's extremely distinctive, because before Apple made that association between Apple and computers, there was no previous association. There's no reason why the competitors need to use the word Apple in their advertising literature unless they're trying to copy off of Apple computers. So an arbitrary term makes a very strong trademark. A coin term, a made-up word like Xerox or Kodak, those are extremely strong trademarks. So those are the most distinctive. So again, to be a trademark, it has to be distinctive. Can't directly describe the product. And also can create a likelihood of confusion with other marks. So you can't just take an existing mark and change the spelling a little bit, or even kind of add another little term onto it. It has to have a distinctive commercial impression from other trademarks out there. If it's the type of thing where other people in the field would be confused between the mark you want to use and existing marks, then you're not going to be able to protect it. So again, step 2, it has to be different enough. And then the last step is to file for protection. Now, filing for protection means it has to have the right subject matter and it has to be the right timing. Assuming that that's the case, that we have the right subject matter we've discussed before, and then we have the right timing, this is how it goes. So if we're applying for a patent, we file a patent application. Patent application is an extremely involved document that describes what the invention is, how it's different from things that have been done before, and really starts the process of convincing the patent office that it's worthy of a patent. That's the big step here, is creating and filing that patent application. Then that application gets reviewed by an examiner. It may be accepted or rejected. If it's rejected, we have an opportunity to respond with arguments to show why the application should be approved. And if it then gets accepted, we pay issuance fees to the government, and then the patent issues as a U.S. patent. Similar process for a trademark. File a trademark application. It gets reviewed. And it might get rejected, and then we have an opportunity to respond with arguments. And then once it gets approved, we need to demonstrate that the mark is in use, that there are products being sold with your product name in your industry, that you're selling products. You supply labels or some other specimen that shows how the mark is being used. You have to actually use the mark selling products out there in order to get the mark registered. And that could have been done before you applied. You could apply as an actual use application where you supply proof then and there, or you file, as I mentioned before, as an intent to use application where you can get to this point in the process. You could file, it could get reviewed, it gets approved, and then you have to show proof that you are actually using it. And then once all of that is done, then the trademark will be registered, trademark gets granted, and you'll have a registered trademark that you could use the R with a circle around it next to your product name, indicating that it's a registered trademark. So, review. 3-step process. First step, determine if it qualifies. Second step is determine if it's different enough. And then the third step is to file for protection. So, here's my philosophy on this, on protecting your products and brands. Protecting your brands is a no-brainer. It costs typically a few $1,000s to get the trademarks fully registered. And if you're looking to build $1 million brand, it's almost insane to try and pinch pennies here and to do it the wrong way, or just not dot your I's and cross your T's and get your brand protected. If you don't have a protected brand, you're not going to be able to sell your business on a large scale. Like it's going to be a deal killer not having your brand protected. Okay. So always protect your brands. Like I said, typically cost a few $1,000s to do so. It's always worth doing. On the other hand, it's not always worth patenting your product. And I'm a patent attorney. I make my living by doing patent applications, but I'm here to tell you it's not always worth patenting your product. And that's not for the reason you might think. I mean, we have over 11 million patents that have been granted as of Tuesday, August 31st, 2021. And then even more, and then another close to a million design patents. Lots of patents have been granted. And some of them are powerful and they're valuable and they're important to the businesses that own them, and have changed industries. And others of them are weak and have little value. That's why you'll see people saying, well, you know, is if you're going to put a product out there, you need to patent it. You absolutely need to patent it. And other people will be saying, well, don't bother patenting. Patents are a waste of time. They change one thing and they get around the patent. And the question is, who's right? And the answer is that they're both right at different times. As it says here, some patents are powerful and valuable and others are very weak and have little value. And I'm going to show you the difference. And it's critical to understand the difference, because you don't want to waste your resources on a patent at the wrong time and for the wrong reason. You go full ahead into patents and you spend tens of thousands of dollars on patenting your first product, and then it doesn't really work out. It doesn't really pay off. And then you get kind of burnt on patenting. And then you launch your second product and your third patent. And maybe your third patent is the one that you should be paying attention to with regard to patenting, but you don't because of that first experience. It didn't seem worth it. So I want you to see the difference here. So first of all, what you want to do is you want to look at what about the product is patentable. What features or combination of features are significantly distinct from what have been done before by others. That's what makes it patentable. See, if you come up with a whole new concept, like you invent the fidget spinner, then you can get a patent on the fidget spinner in general, and that could be a powerful patent because it's a whole genre. But you do your research, you find out that there are lots of other fidget spinners before it, and then it's like, well, what makes mine different? Oh, it's that I have these 3 wheels with the ball bearings and these 2 gears that are in mesh. So that's what makes it patentable then. And then if you got a patent, it would be on that specific combination of features. So you have to look at that. If those are the combination of features that makes it different, then that's going to be what's patentable. But then next you want to look at, kind of what makes it marketable. Like what aspect of the product are the thing that your consumers, that the competition are going to be looking at, that things that the consumers want. Do they want those 3 wheels and those gears in mesh, or could they care less? It could be a different configuration. So you want to look at what's the thing that makes it marketable. What's the thing that's important to the customer? And it's so important to the competitors because they don't want to make a product that doesn't have this feature. They don't want to compete if they can't copy that feature that is the one that makes it marketable. And when you have a combination of those two, when what makes it patentable overlaps with what makes it marketable, when the features that matter to your customers and to your competition are also the features that make it patentable, that's when you have a powerful patent opportunity. And that's when you want to consider patenting something. If constrained, if the patent would be constrained to details that don't matter to your customer, then it's not worth it. But that's what you want to look to decide whether you have a powerful patent opportunity. And in general, if you want to learn more, I could tell you, I wrote a book for the American Bar Association that explains in plain English how patents work. ABA Consumer Guide to Obtaining a Patent. If you want, I'll send you a copy. You could just contact my office here, assist@goldsteinpc.com. And you want to learn more about the process, also go to my website, goldsteinpatentlaw.com. In general, I feel that patents is something that if you learn more about, it could tremendously help your business. So it was great doing this presentation here for Resonate, and good luck with your selling journey.